My name is Angelina Partridge. I'm the Acting Deputy General Counsel of the Cayman Islands Monetary Authority, and I'm here to give a presentation on the regulatory perspective for legal entities, some pitfalls and concerns that we have when we're considering structures from an AML perspective. So here in front of you, I have an example of what is a relatively straightforward structure that many people will see when they're looking at their licensees. You'll see in the center is a Cayman entity. In this case, it's a licensee regulated here in Cayman. Investors are coming in from a separate country. We'll call that country B. It has 4 UBOs who are holding the company through a holdco in country A. Above that holding company, off to the right, you'll see it's a gold company in gold, which we're calling the common corporate trustee. That common corporate trustee holds 19 private trusts on behalf of those 4 people. Now, those 4 people, the 4 UBOs, are also 4 of the 5 directors. The other director is a Cayman resident. Underneath the Cayman licensee, you can see I have the service providers. There's the asset manager and the administrator, both in country C, and the investment manager and the back office, both in country B. So, pretty straightforward structure. One of the questions that comes up and why we look at this from a regulatory perspective is what happens if something goes wrong? And just to give you an idea, this is a simple structure. It's a common structure. In this case, this is an example of a structure that does actually exist or did actually exist in Cayman and was on our books and had been introduced prior to the amendments to the AMLRs in 2017. So this is a historic structure that no longer exists, but did end up coming under regulatory scrutiny. So what could go wrong and what did? Well, there was an AML and prudential supervisor, similar to what we do here at CIMA, which we'll call Supervisor B, because it's from country B, which received a complaint about a separate party in a parallel structure, and that party was related to the investment manager. Now, based on their preliminary investigation, they found that funds from the investors in the Cayman licensee were fraudulently conveyed to the investment manager to improve the balance sheet of other entities managed by the investment manager that weren't part of this original structure. Why did this happen? So that the investment manager could improve their performance fees and their performance management fees based on the returns that they were getting in that parallel structure. In order to do this, they may have also been involved in some minor embezzlement, bribery, civil collusion, etc., amongst other parties related to the investment manager, and their eventual defense was that this was potentially accidental. So we now have a situation where an investigation has to be conducted because investor money is missing. Cayman is being asked to assist the supervisor, Supervisor B, to conduct this investigation. So Supervisor B is asking Cayman authorities for basic, straightforward information that should be maintained in Cayman for that Cayman licensee because it's information that should be booked in and with the Cayman entity. That information is registered shareholders and UBOs of the Cayman licensee. Where does the Cayman licensee hold its bank accounts and how much is in those bank accounts? And how do the funds flow from investors through the Cayman licensee to the investment manager and any of the service providers? So, for example, is it through multiple accounts? Is it face-to-face? Are they wire transfers? Those sorts of questions. So, CIMA, like other regulatory authorities, has domestic and international obligations to assist with other investigative authorities based on bilateral and multilateral agreements, and you can find those agreements on our website at www.cima.ky. We can get some of that information from the registered office in some cases, such as shareholder and beneficial ownership information. That depends on the nature of the information that was collected by the registered office at the time of onboarding. But most of the time, the registered office doesn't maintain bank account information. So in this case, that bank account information would be with the administrator in a separate country, as you'll recall, country C. We could try the back office, but that's in country B. The asset manager might, very unlikely, but it's possible, that's also in country C. One of the things that I didn't say is that in this particular example, all of the service providers in the structure were all owned and controlled by the same 4 UBOs. And again, that's not terribly uncommon in Cayman structures. So we're faced with a situation where there's no independent means in Cayman to gather all of the information held by the company regarding the flow of funds, the assets, shareholders, and UBOs. So what about our sole independent director here resident in Cayman? Well, the reality is it's unlikely that that individual is going to have their own personal separate copy of the books and records. Most people don't keep that duplicate copy. In addition, it's unlikely that if it's someone that's trying to keep the information away from that independent director, that they're going to have full insight into all of the accounts and all of the transactions, or if someone's really trying to keep it away from them, even the full beneficial ownership of the entity. One of the things that we always have to remember is that if someone is actively trying to evade oversight, it's unlikely that they're going to confide in the one innocent party, the one independent party in this whole structure. So what's the kind of information that CIMA is likely to be able to get? Well, the reality is probably not much. We are speaking about a structure that would have been established prior to 2017, so this would have been prior to the amendment to the AMLRs. The new AMLRs is a lot stronger and a lot more prescriptive in the information that would have been required to be gathered. So prior to 2017, many registered offices wouldn't have gone past that first holdco in country A. So now, we don't really have much information past that holdco. If they did, they may have gone up to the second level to find that second nominee. That foreign trustee would have been acting for 19 trusts benefiting 4 individuals. Well, it's unlikely as well that we would have found out why that structure was so complex. At the end of the investigation and when everything started to become more clear, we found out that it was to hide the fact that the UBOs were actually the same 4 individuals. But at the time, the information that was available was that the structure was complicated for the purposes of tax planning. We all know tax planning doesn't quite give you the full extent of why this kind of structure exists. So now, more registered offices would look more into depth to find out what someone means by tax planning, rather than just stop at, oh, tax planning, 19 trusts, 4 individuals. It's a rather complex structure for just tax planning. In this case, because no account information is being maintained in Cayman, this isn't anything that we'd be able to find. Therefore, there would be no way to determine how much is held in those accounts. Because you can't determine how much is held in those accounts, it's impossible to determine what the flow of funds are. So the result is that CIMA is unable to assist with basic information on a Cayman Islands company because that information is not maintained in Cayman. And the supervisor B is then sent off to investigate a Cayman company through other countries, not through coming to Cayman and getting the information here. So this shows us that there's some things that we can learn about what makes an entity easier to supervise versus what makes an entity harder to supervise. And this then leads into the risk-based approach to supervision, which is the regulatory perspective. So lower risks, therefore, tend to be indicated by entities that have a physical presence with office employee and employees. If I can walk into your office and gather your books and records and interrogate your employees, I tend to be able to get more information. And when I say interrogate, I mean ask questions of and gather information from. If bank accounts tend to be in Cayman or have local persons who have signing authority on those accounts, I'm able to get more information. If there's a straightforward ownership structure with a clear rationale, this tends to be an indication of a lower risk. And if there are local service providers other than a registered office. The key here isn't that this is an indication of a low-risk entity, but just that these are factors that tend to indicate lower risks. On the other side, factors that tend to indicate that something is a higher risk are entities that don't have a physical presence or local employees, entities that have no transactions being monitored by a physically present Cayman entity, and entities that have opaque structures for reasons that can't be discerned. So if you can't explain it to a teenager, it's too complex. I know that's a very simplistic statement, and actually things are a little bit more detailed than that, but ultimately it should be something that can be explained quite straightforwardly. So what does the next steps for CIMA mean in the risk-based approach? Well, first thing that we're working on currently is the establishment of the AML division, which will help us focus and enhance our risk-based approach to supervision. And part of that will then, of course, involve incorporating different structures into entity and sectoral risk ratings. So an entity risk rating is each individual entity and how the transparency of its structure and its touch points to Cayman tends to show indications of lowered risk or higher risk. Sectoral risk ratings are, again, the types of entities favored by a particular sector of the economy and how the use of those particular entities tend to become factors in raising or lowering those risk ratings. In rare cases, and some people may have come across this already, if an entity is particularly opaque or hard to supervise, we have the option under some of our laws to require a restructuring or to inform an entity that we are not going to register or license. And in some cases, if an entity wishes so, we can provide them with an option to terminate for administrative reasons. But those circumstances are very rare and tend to be situations where we try to work with people quite a long time before those options are initiated. So I'd like to thank you very much for joining me, and hopefully we can provide more information in the future and more examples like this as to how legal persons and arrangements can be indicated for more or less risk. Thanks.